Good morning, viewers. Welcome to this law lecture series. Today's topic is an introduction to the Code of Civil Procedure 1908, part 2nd in English. Very soon you will have the Hindi version of this lecture also. Here is the synopsis of the topic. First, scheme of the code. Second, nature and scope of the code. And the third, the Commercial Codes Act 2015. Scheme of the code, nature and the scope of the code, and the Commercial Codes Act 2015. Three main heads. Now I am coming to the first main head, the scheme of the code. I have divided the scheme of the code into three parts. You see, first, preamble, second, body of the code, and the third, the first schedule. Let us take up them one by one. Preamble. A preamble to a statute is said to be the identity card of the statute concerned. A preamble to the statute is called as an identity card of the statute. It gives a very general introduction to the act. Look here, preamble to the CPC. The CPC is an act to consolidate and amend the law relating to procedure of the courts of civil judicature. It is clear from the preamble that the CPC is a consolidating act. The CPC is an amending act. And it consolidates and amends the law, procedural law relating to the civil courts. Civil courts or courts of civil judicature, same thing. The CPC is an act to consolidate and amend the law relating to the procedure of the civil courts or the courts of civil judicature. It's a consolidating act. What does it mean? It means that the CPC aims at collecting and consolidating all the scattered rules relating to the procedure of the civil courts at one place. All the rules which were scattered here and there, they have been taken together and put at one place. This is called consolidation. Secondly, it is an amending act. Various rules relating to civil procedure were not up to the mark. The experience showed that they have some defect. There is some practical difficulty. So, the rules were amended suitably to cope up with the existing needs of the courts and the litigants. Now, body of the code. Scheme. First, preamble. Now, second, body of the code. Body of the code comprises 11 parts. Body of the code comprises 11 parts. And one caption, preliminary. The body of the code has first part, preliminary. It contains sections 1 to 8. Various preliminary matters have been given, sections 1 to 8. And then there are 11 parts, parts 1 to part 11. section 9 to section 158. So first 8 sections have been put together under the heading preliminary, and sections 9 to 158, they have been put in 11 parts, part 1st to part 11. So section 1 to 158 is the body of the code. The body of the code, that means these sections from 1 to 158 are of substantive nature. Since they are of substantive nature, they are to be amended only by the Union Parliament or by the concerned state legislatures. Who can amend the body of the code? The Union Parliament and also the state legislatures. Can the body of the code be amended by the High Court also? No, High Courts cannot amend the body of the code because it is substantive in nature. It is amendable either by Parliament or by the state legislature. High Court has no power to amend the body of the code, sections 1 to 158. Look here. Who can amend the body of the code? The Parliament, the state legislatures, not High Court. Not High Court. And the body of the code is of substantive nature. Preliminary sections 1 to 8, remaining sections 9 to 158 divided into 11 parts. Now, CPC has been amended on more than 70 occasions. The code has been amended on more than 70 occasions. Several Amendments Act and adaptation orders have been passed from time to time. So these are the new sections. Body of the code. In the body of the code, these sections have been inserted. And from the body of the code, these sections have been taken out, omitted. And these 3 sections, they have been altered, inserted, omitted, altered. Now, third, the first schedule. The scheme of the code. First, preamble. The scheme of the code. Second, body of the code. The scheme of the code. Third, the first schedule. The first schedule to the code is procedural in nature, and it contains various orders containing hundreds of rules. The first schedule to the code is procedural in nature, and it contains orders, order 1 to order 51. Besides orders, it also contains certain appendices. Appendix A to Appendix H. In all, there are 8 appendices. Orders 1 to 51 containing various rules. Those rules supplement these sections. Whenever you read CPC, you read the substantive sections together with supplementary rules to be taken from the order concerned. Sections and orders both are to be taken together. Substantive part is to be found in these sections, and the procedural aspect is to be found in the rules given in orders. How many orders are there? 1 to 51. And how many appendices are there? 8. Appendix A to H. These appendices contain pro forma of the plaint, pro forma of the written statement, pro forma of the execution application, pro forma of the summons. Various procedural pro forma have been given in these appendices. A to H, 8 in number. So this is first schedule. This is procedural in nature, and look here, it can be amended by the parliament, by the state legislatures, and by the high courts also. Procedural है. It can be amended by the union parliament, by the state legislature, and also by the high courts. First schedule. Are there second schedule, third schedule, fourth and fifth schedule? No. Now second schedule, third schedule, fourth and fifth schedules, they have been repeated. Only the first schedule containing orders 1 to 51 containing appendices A to H remains. The succeeding 4 schedules, they have been repeated. We don't have now schedule 2, 3, 4 and 5. See here, second, third, fourth and fifth schedules repeat. Only first schedule survives, having orders 1 to 51 and appendices A to H. Orders contain rules and appendices contain pro forma. Now this is the scheme of the code: preamble, body of the code, and first schedule. Now see here, nature and scope of the code. Nature and scope of the code. First point is whether the CPC is retrospective. Is this code retrospective in nature? No. The code has come into force with effect from 1st January 1909. It is not retrospective in its operation. The matter has been raised. The matter has come for court's consideration in various decisions. One of the leading cases is Mohanlal Jain versus Savai Man Singh Ji. Mohanlal Jain versus Savai Man Singh Ji, 1961. In this case, the Supreme Court has categorically said that the Code of Civil Procedure is not retrospective. Now, second point, whether the CPC is exhaustive. No, the CPC is not exhaustive, but the matters which have been specifically dealt with in the code, on those matters, it is definitely exhaustive. In general, the CPC is not exhaustive. It does not contain all the rules relating to the procedure of the courts of civil judicature. In general, it is not exhaustive. But the matters on which the code specifically provides, on those matters, it is definitely exhaustive. Since the code is not exhaustive, problems may arise before the court, situations may arise before the court where any provision of the code is not clear, or where the provision is silent, or where the provision is missing. In that eventuality, the court is to decide the case by exercising its inherent powers. The inherent powers are those powers which a civil court possesses to do justice and to undo injustice. Inherent powers of the civil code have been said in section 151 of the code. Inherent powers have their basis in the principles of justice, equity and good conscience. When any provision of the code is silent, or when it is ambiguous, or when there is no specific provision on a given point, in that case, court exercises its inherent power to do justice and to undo the wrong. And the basis of this inherent power is principles of justice, equity and good conscience. Now the last one, the Commercial Codes Act 2015. This is very important. The Commercial Disputes Act 2015. The full name of this act is the Commercial Codes, the Commercial Appellate Codes, Commercial Division and Commercial Appellate Division of the High Courts Act 2015. Please listen to the full name of this act. Short name is the Commercial Codes Act 2015. But its full name is the Commercial Codes, the Commercial Appellate Codes, the Commercial Division and the Commercial Appellate Division of the High Courts Act 2015. This is Act number 4 of 2016 and it has been given retrospective operation. It has been meant to apply with effect from 23rd October 2015. What for this enactment has been brought? This is a central act. Commercial disputes. It relates to commercial disputes and commercial disputes of specified value. Commercial dispute has been defined in section 2C of this act and specified value has been defined in section 2I read with section 12 of this section. So if there is a commercial dispute and that too of a specified value, what is here meant by specified value? Minimum valuation 1 crore. Earlier it was minimum valuation 3 lakhs. Now it has been raised to a minimum valuation of rupees 1 crore. So there must be a commercial dispute and that must be of a specified value. That means not less than valuation of 1 crore. With regard to this type of commercial disputes of a specified value, some of the sections of the CPC and some of the orders of the CPC have been amended. But those amendments are confined only to the matters falling under the Commercial Codes Act 2015. In case of ordinary civil suits in ordinary matters, these amendments in the CPC, in the orders, in the section, they will not apply. But if there is a commercial dispute of a specified value, some of the sections of CPC and some of the rules of the CPC have been amended. Those amended sections and rules will apply with regard to commercial disputes of a specified value. That's all in this lecture. Thank you.